Welcome to this webinar about dealing with breaches under GDPR. I hope you're all up and running and GDPR compliant and have got past the what appeared to be quite a panic in the run up to the 25th of May. But we're here now. We're post GDPR. We're all still alive. Everything's still working, and we are all good in terms of GDPR compliance. But of course, one of the things about GDPR, and I'll talk about this in a second a bit more, is that it's not just about, or it wasn't just about the 25th of May. Ongoing compliance is a key thing that needs to be considered, and breaches is one of the areas of GDPR that that you need to have your wits about you in terms of bearing in mind what to do if a breach occurs, and that's what this webinar is about. So very quickly, as I said, my name is Mark Gracie. I run a consultancy called Flavorfied Digital and an online service called Digital Compliance Hub. And I work with businesses helping them with data compliance, obviously in the lead up to May. And in fact, since then, I've been working almost solely on GDPR compliance, but I also deal with e-privacy, marketing compliance, web and data security as well. And the e-privacy and the marketing compliance aspect is set to all change as well. If you've not heard about the e-privacy regulation, which is currently being discussed at the EU level, that's a new regulation that might change some of the stuff that you're doing with marketing, particularly digital marketing. So it's worth looking out for that. And if you visit the Digital Compliance Hub website, there's a link from the bottom of all the slides. And I'll talk about Digital Compliance Hub a bit towards the end. The next webinar I'm doing next month is about the privacy regulation, what we know and what it might look like, and it's likely to change things about cookies, digital marketing, and particularly consent. But that's enough about me. Let's focus on what we're going to talk about today. So I'm going to talk about data breaches from a GDPR perspective, and basically sort of cover off what the GDPR says about breach reporting, what you need to think about in terms of how do you determine whether it's a breach, and what you need to do about it, and sort of look at some of the detail around that. As I say, if you have any questions, use the question panel and we'll pick those up towards the end. But let's move along. So as I've already said, GDPR came into force on the 25th of May this year. Breaches is one of a number of elements of GDPR compliance that most organizations needed to worry about. And of course, I think probably the one that got most people's attention, in some cases wrongly, or if not being a bit reacting, is the consent changes and what that might mean, particularly from a digital marketing point of view. But we're not going to labor on that, but I'm guessing most people on the webinar have at least some exposure to GDPR, and thanks to the overload of consent emails that people were receiving, needing to re-seek consent, as I say, sometimes wrongfully or rightfully, has probably raised awareness of GDPR in a much better way than anybody probably ever imagined. But the focus, and this slide sort of represents what I've always seen as the key changes that GDPR introduced, but one of the key things which is new for most businesses, not all, because some organizations already had a duty, and in fact have duties in parallel to what the GDPR says about breach reporting. Those are typically telecoms operators and some infrastructure providers, but I'm not going to focus on those particular areas specifically, but focus purely on what the GDPR says about breaches and the requirement under some circumstances about breach reporting. Now, the ICO, the Information Commissioner's Office, carried out ran a webinar a few weeks ago about breach reporting, and they didn't say much more than what their website says, but they did actually impart quite some interesting information and statistics, and they've seen that since GDPR's come in, and certainly in the lead up to the 25th of May deadline, they saw almost, I think, a 2 or 3 times increase in the number of contact that they've had with people reporting breaches. Now that they seem to suggest that they're dealing with what they're dealing with, probably a couple of hundred a month in the lead up to GDPR, and now GDPR has come into force. That went up to about 600-700 a month. But they also alluded to the fact that there were a lot of people who were panicking around what it is that they're supposed to be reporting. So they're sort of erring on the side of caution and reporting everything, which I guess is a bit of a nuisance if you're the Information Commissioner having to deal with all the compliance issues, let alone people reporting breaches. But I guess it's not so helpful for them if they don't need to deal with all these breach reports. So in my mind, if you're unsure about what it is you're supposed to be doing, and you're not sure what your responsibilities are and the 72-hour timeline and all these kind of things, then there's probably a good indication that you're not fully up to speed with what GDPR means in total. And the last thing you want to do is highlight to the Information Commissioner that you don't really know what you're supposed to be doing, because that indicates that you might not know what you're doing in other areas as well. And there was certainly an element from what the Information Commissioner reported, or their representatives reported, with regards to the kind of reports they're getting. So if you're worrying about breaches, you're not alone, and hopefully this webinar will provide the background and information and some of the understanding about what the law says and what you need to think about. Because whilst the law says you must report certain types of breaches, and we'll talk about that in a bit more details a bit later, but there's also a general sort of compliance point that needs to apply within your organization in terms of what it is that you probably need to do, be it mitigating risk and actually what do you do when it comes to having to consider a breach. So hopefully we'll cover all of those and answer any questions you might have at the end. So when it comes to breaches, the GDPR and indeed the general guidance and advice is that actually breaches are much wider than most people would realise. We tend to hear about in the press, and in maybe you've been impacted yourself with some of these larger providers in terms of what they're experiencing where they've had cybersecurity incidents. So we tend to think about breaches as being sort of the atypical spotty teenager hacking a system just for the sake of hacking it, and then releasing the data. So we hear in the media about breaches, and where there's been things with some of the big consumer brands recently, and I've certainly had emails from some subscriptions that I belong to with systems that I'm sure you probably read about, telling me that their database had been hacked and that there was probably no personal data stolen and those kind of things. So we tend to think about a breach being a cybersecurity incident, somebody getting access by hacking into a database and then copying the data, or and you might not know that that's happened until you hear about it, because it's somebody has contacted you that they might have thought that actually that data was only available to you, so somebody else knows it now, then maybe you've had an incident, or the data in question is for sale on the internet and on the dark web or whatever. And that's why we tend to hear about these things like Yahoo having a breach from about 3 years ago and not realizing and so on. So, but the important thing to realize is it's not just those security incidents or those cybersecurity issues that you need to think about, that you do need to think about those if data is stolen or accessed unlawfully, then that is could be considered a personal breach, and the circumstances of the type of data and whose data it is would influence the outcomes in terms of what's needed to be reported. But it's not just that. You might lose a device that has access to data. You might lose a device that has data on it, or it might be stolen. That would constitute a breach as well, as would anybody viewing the data that isn't authorized to view it. So from a from a sort of a rough kind of example, somebody viewing, if you're working on a train and somebody's looking over your shoulder and looking at what you're doing on your computer and you're accessing personal data, well, in practice, that is a breach. The question is what that might mean in terms of whether it's reportable will depend on the circumstances and what that person might do with that data. but any unauthorized access, or including viewing, and that could be that employees who are not supposed to see your data and have no reason to access data, if they access data, then that's a breach. If you leave data lying around in your office and a cleaner comes along and picks up the data, or accesses a machine that has access to data and there's no passwords or whatever, yes, there's security issues and you've got the security principle to think about, but that's unauthorized access to the data. But it's not just access data being lost and stolen or cyber security incidents. A breach, as defined in the GDPR, is also other aspects of it. So somebody having the inability to access their data would be construed a breach, and the implications of, for medical information, for example, if that's not accessible to help with treatment, then that has serious ramifications on the data subject. And then there are also unauthorized changes. So if data gets deleted or changed or edited or manipulated without the right permissions and without the right authority, then that is also a breach. So I've probably over-labored that point. It's not just about cybersecurity incidents. It's about theft of data, unauthorized access, unauthorized changes, and even the inability for the data subject to have access to their data. And that's why it's quite important to understand the bigger picture as to what constitutes a breach, so that you understand what that might mean within your own organization. So what does actually the GDPR say, other than talking about what a breach might be considered as in terms of what we've just discussed? But what else does it say about breaches? Well, it essentially says two things. There's two articles, Article 33 and 34. Article 33 is about the consideration about whether you need to report the breach to the Information Commissioner's Office or the regulator in your country, which in the UK is the ICO, the Information Commissioner's Office. And Article 34 is the consideration about whether you also need to tell the data subjects. And this is one of the key things that I always sort of said when I was talking about the GDPR changes, is that it's not bad enough that you've had a breach and you're having to deal with the consequences of what that might mean for your organization, be that patching a security hole or dealing with an employee who didn't realize that they were breaching security or whatever, but you're having to consider, do I need to tell the regulator that I might have some security issues that has led to a breach, which might put you on their radar in terms of an investigation? But you also got to tell your customers, essentially. And so, what does that mean to you in terms of what that would, how that would impact your relationship with your clients? And if you've done any looking at cybersecurity in a general sense about security and the implications and the cost of cybersecurity incidents, then you'll know that actually, it's more than just you've had this impact. You've got the PR issue, you've got the fact that you've lost data, the fact that you are losing trust from your customers, and so on. So the law says you need to consider whether you've got to report it to the Information Commissioner and whether you need to tell the data subjects or your customers, your clients, whoever it is that whose data it is you're processing. Now let's look at those in a bit more detail. Article 33 talks about the need to consider whether you need to report it to the regulator, which, as I say, in the UK is the Information Commissioner's Office. And essentially it says you've got 72 hours from being aware that there has been an incident and a breach to consider whether it needs to be reported. You need to consider that if there is a risk to the data subjects, that you need to tell the Information Commissioner, and you also need to keep a record. Even if you decide not to report, you need to have a record of what breaches have happened and what you decided to do about them. And often I get asked, well, why would I keep a record of a breach that I decide not to be reported? Well, actually, if something happens that you didn't realise, the breach was maybe more severe than you thought it was, then there's a good chance you might be asked to explain about this breach. And if you don't have a record of it, even if you didn't report it, you wouldn't. You're going to be in a bad situation, particularly with the regulator, because you need to be able to say, well, actually, we did have a breach. It wasn't something we considered was needed to be reported, and this is the outcome, and this is what happened. Well, if you've not recorded that, then you won't have any of that detail to be able to have that discussion, and therefore that probably wouldn't look so good in terms of the conversation you will be having with the regulator. Now, in terms of what you would have to report, should you consider that you do need to report, and I'll talk about what risk to the data subjects might mean and in a couple of slides time, but in terms of the kind of things that you would be expected to tell the regulator should you decide you do need to report it, is things like details of what the breach was in terms of what's happened, what you're doing about fixing it right now to make sure that you mitigate any particular risk, and as well as making sure that it doesn't happen again. Details about the data, the number of data subjects impacted, which might also mean you need to explain what that means in terms of the number of records, because it could be multiple records for a small number of subjects, and that would all have an implication as well. What the consequences of the breach are in terms of the data subjects and the outcomes for them with regards to that data being lost or unauthorized accessed without authority, as well as sort of more admin related things like who they can contact. Typically that would be the data protection officer. If you're not mandated to have a data protection officer, you might have somebody within your organization who is the go-to person on data protection, and so a contact point that they can keep in touch with is probably of use as well. So the key thing is the 72 hours, and it's 72 hours from the point at which you are aware that there is a breach. Now that would be you as the organization, not you as the data protection officer or the person who is supposed to be told about breaches so they can decide what to do about it. So you'll need to think about the fact, and we'll talk about this in a bit, about how you deal with that fact that somebody within an organization may be aware that there's a breach occurred but did choose not to do something about it. So there's an education and awareness piece there as well. But you've got 72 hours from the point at which you become aware as an organization of breaches can happened to actually report it. If you don't have the full details, or you can't provide any information about how you've mitigated the risk or what you're doing to fix it, then you still have to report at least something within 72 hours to the Information Commissioner and keep them up to date and appraised as to what's going on. So, but this only happens if you only need to do this if there's risk to a data subject, and what that might mean we'll come to in a moment. But first, let's talk about Article 34, which says you need to consider whether you need to report it to the data subjects. Now, you might report it to the Information Commissioner, but won't need to report it to the data subjects. This will depend really on the situation and the consequences for the data subjects as to as to whether you need to report it. And the key word I've highlighted there with an underline is high, as in high risk. So if there's a risk to the data subjects, you've got to tell the ICO. If there's a high risk to the data subjects, you've got to tell the data subjects as well. Now, you don't have such a fixed timeline because the regulation talks about reporting it to the data subjects without undue delay, and in true legislative ways, undue delay is not clearly defined, but you would have to basically justify why you've left it so long if you decided to leave it for a long time, and you would need to be able to clearly demonstrate that it was a reasonable period of time. So basically, you should tell the data subject if there is a high risk to them from the loss of the data, that you do that as soon as possible. And again, you need to keep a record of the fact that you told the data subjects. Obviously, you're keeping a record of the breaches anyway. You just need to reflect upon whether you told the data subjects or not, and be very clear in your own minds if you chose not to, why you didn't. And in terms of what you tell the data subjects, that's the bullet points on the right. You basically need to tell them what's happened, what the impact is of the breach, what that means to them in terms of their data, what measures you have been taking to mitigate any future issues and to fix the breach and prevent anything happening in the future, and also again a contact point for them to get in touch to ask questions and so on. Obviously, if it's a significant breach, then you will probably need to have some information to hand, be it on a website or in the communication, that kind of frequently asked questions kind of thing. Now, the other thing to bear in mind, just going back to the ICO, and if you chose to report it to the ICO but not to the data subjects because you didn't believe it was high risk enough, the ICO does have a power that they can actually tell you that you should tell the data subjects. So even if you get to this point and say, well, actually, we don't think it's high risk, we're not going to report it to the data subjects, if the ICO believes that you should report it, even though you don't think you do, then you will end up having to go down this route anyway. So 2 things to consider. You need to tell them within, you need to consider whether the risk is a high risk to the data subjects' rights and freedoms, etc. And I'll talk about what that might mean in a moment. And you've got to do it without undue delay. But the starting point is always going to be, do I need to report it to the ICO? If you don't need to report it to the ICO, then it's not going to be a risk to the data subjects, and therefore you don't even need to worry about whether it's going to be a risk to the data subjects. You just need to keep a record that a breach occurred, you chose not to report it, the reasons why, and some general information about the breach. So if you are questioned and asked about it, you're able to answer those questions. So 2 key things: do I report it to the ICO? Do I report it to the data subjects, your clients, your customers, your contacts, or whoever's data it is that's being breached? Now, the question that I think goes back to the point I said earlier, which is the ICO saying that they were being bombarded with people not really knowing whether they were supposed to report it, is that there is this question about, well, what is a risk to the data subject to make it something I have to report to the ICO, and what is a high risk to report it to the data subject? And unfortunately, there's no easy answer to this, and that's why I've quoted something from Recital 85 from the GDPR, which kind of talks about what it considers, or what the regulators, when they drafted the regulation, considered to be a data breach, and it covers a range of different elements, from physical and material, or even non-material damage to the data subject. The loss of their rights, the outcome of the loss could lead to discrimination, particularly if you're dealing with special categories of data. There's certainly things there that could lead to sort of discriminatory actions from people who become aware of information. Of course, most data subjects are more concerned, or probably more likely to be concerned, about identity theft or financial fraud or loss. But that paragraph there, covers a wide range of things. Now, the problem is, in determining whether it's a reportable breach, is you will need to look at the incident, and you will need to look at the case, and you'll need to cast your own decisions upon this, which is, again, why it's so important that you record details about the breach, because you need to be able to demonstrate that you've thought this through and you reached the right conclusion. Now, if you reach the wrong conclusion, if you've got a good reason why you're able to explain why that happened, then that's always going to put you in a better place than not, just thinking, well, actually, I decided I wasn't going to report it because I didn't think it was a risk, and now I've got no evidence of that thought process or anything like that. And yeah, I think this is the key thing, and this is the key problem the Information Commissioner has, is people are saying, hang on, I don't want to take the risk of being caught out for not reporting something, so I report absolutely everything. But in reality, you probably want to look for the opportunity to say, well, actually, what is the risk to the individual from this breach? Is it going to be an issue that has an impact on that individual with it becoming public information? And if it meets any of these criteria in a lot of detail, and the Information Commissioner makes use of this reference to the Recital 85 as well, in terms of determining what might be reportable. And of course, the ICO isn't going to be very prescriptive, because that will narrow down any particular controls or guidance they might want to put in place in the future. But you need to look at them on a case-by-case basis, I'm afraid, and work it out for yourself. But your sort of saving grace is if you can document your thought process and your decision making around what you concluded to do, particularly if you decided to do, particularly if you concluded that you're not going to report it, then that's probably the saving point for you in terms of being able to demonstrate that you at least thought it through. It's not in your business's interest to report breaches for the reasons I said at the outset, which is, you're going to be telling the regulator that something's gone wrong with your data security, which is a principle of data protection, of course, and you're possibly going to have to tell your customers that you might not be able to be trustworthy with their data. So you need to be very careful that you don't err on the side of not reporting, but at the same time, don't think you have to report everything. And I would say, if it's a small number of data subjects where the risk is very limited from the impact that it will have on them because of that breach, because hardly anybody saw it, or the person who saw the data, if it was an isolated incident where you sent data to the wrong person, they've said, I shouldn't be seeing this, here it is back, I've deleted the copy. You can say, well, actually, that's a good example of where the risk is so small that you can perhaps trust the individual that they're not going to do anything further with it. They've given you the data back. It's not out there on the internet or out in public domain, and therefore the risk is limiting, and therefore you just document that, and that is the reason why you didn't report it. Obviously, if you're using thousands of records relating to thousands of data subjects and it relates to billing information, unencrypted passwords, unencrypted data, those kind of things, then you've got more of a tougher decision to make, and you'll need to look very carefully at sort of some of the wording of these examples of what constitutes a data breach. So apologies, I can't give you a black and white answer on what is and what isn't reportable. And as I said, I think that's one of the challenges for organisations in determining whether they've got to report a breach, and in terms of what the regulators are having to deal with, because people are erring on the side of caution. But one of the, I guess, one of the key things that is always worth bearing in mind is, well, how do you prevent getting a breach in the first place? And, how do you mitigate that risk? What are the kind of things you need to do? And I kind of alluded to this in some of these things when it comes to things like knowing that you've had a breach and having that 72-hour window to consider whether you report it to the regulator or not. Because one of the key things is making sure your staff are aware of what a breach looks like, and that they know who to go to report it, so that you can then start that 72 hours clock ticking and working out what you need to do to fix the problem, as well as what you need to do to decide whether you've got that need to report. And whilst that's not the top bullet on that list, it's the third one. Make sure your staff, your employees, people who are handling your data, understand what their responsibilities are if they are aware of something that's not quite right, and that a breach of data has probably occurred. So they need to understand the basics of what a breach might look like. They need to know who to go to tell that they think a breach may have occurred, and they need to understand that they should err on the side of caution and go and talk to the data protection officer or the manager or whoever it is that they need to speak to, rather than sort of try and bury it if they think it is a breach. Of course, before that, you want to have a breach policy, so something within your organisation that sets out not only to the person who's dealing with it, with sort of setting expectations around the 72 hours, whether you've got to report it or not, and how that process works within the organisation, but also making it clear to the organisation that they understand that there is this process in place that they need to follow should they come across a breach or have concerns that a breach has occurred. And then right at the top, which is really where I should have started, really, of course, the best way of mitigating the risk is not having the risk in the first place. You'll never 100% be able to put your hand on your heart and say we will never have a security incident, because there are so many different factors involved, be they human ones or technological ones. But don't forget the GDPR, the data protection principles that have been in place since the 1998 Act of security, that you have to put in place appropriate technical and organizational security measures around your data and the personal data that you're processing and storing and maintaining within your organization. If you do as much as you possibly can, and again, if it comes to the crunch and you do need to tell the regulator, you're going to be asked questions about this, about, well, how did this come to happen? What did you do to make sure that technically the risk was low, and organizationally you would put in place the right training and the right understanding about what is to be expected. And of course, the GDPR talks about things like encryption and security software and pseudo-anonymization and so on. And it will be up to you to be able to demonstrate that you've done the right thing in terms of what is to be expected with the kind of data you're processing and the circumstances by which it's accessible and available. You don't need to always encrypt data, but of course, if the data is encrypted and a device is stolen and the hard drive is taken out of that device and then plugged into something else, well, if that hard drive is encrypted, then it's not going to be accessible, and you would be able to argue that you didn't report it because all the data was encrypted and therefore not accessible. If you're dealing with thousands upon thousands of records, you might still want to report it, but with the good news that actually there was no risk because the data subject's data was covered by encryption. But that will depend on what technical and organizational measures you've put in place. So, sort of summarizing in terms of where things sit with breaches, Articles 33 and 34 of the GDPR enforced in the UK because the GDPR applies in the UK, but also Data Protection Act 2018. You've got to consider, do I report it to the ICO? Do I report it to the data subjects? There needs to be a risk to the data subjects to report it to the ICO, and there needs to be a high risk to the data subjects to tell them as well. But if you get the right technological and organizational measures in place security-wise, then you'll meet the principle of data security within data protection legislation, which will obviously minimize that risk, but make sure you've got a breach policy in place. Make sure everybody across your company understands, or your organization understands what a breach looks like and what they should do, and make sure you've got somebody who is clearly aware that they have to take responsibility for considering whether a breach is reportable and to follow the breach policy. So that was really, I mean, in considering the complexity of the GDPR as a whole, as a piece of legislation, and certainly complexities around the Data Protection Act 2018, that's probably as much as what can be said about data breaches, and the key question is really determining whether it's something that needs to be reported, and that's unfortunately on a case-by-case basis. So just to wrap up before we go to any questions, as I said at the beginning, one of the services I offer is called the Digital Compliance Hub, and what that is an online service that helps support businesses with guidance, information, toolkits, and a helpline. So if you've got a question, you know, if you suffer a breach and you want to know, I guess, get a second opinion about whether it's something that's reportable. I don't need to have the nitty-gritty of all the detail and understand what the data is in lots of complex detail, but you can use the Digital Compliance helpline and support service to get some advice and guidance about the breach policy, about your how you deal with breaches, and maybe some specific questions should something arise. So the Digital Compliance Hub addresses at the moment primarily around GDPR, but obviously, as I said earlier, with the privacy regulation coming, there's going to be a lot more available relating to that, as well as web and data security. So it's information guidance toolkits, and there is a section which I've started developing around data breaches, including a poster that you can use for your employees to understand sort of the basics in a very bullet pointed perspective, and so on. And if you are interested, if you've not tried it already, then you can try it for free for 14 days. And some of the content isn't accessible until after the trial period, but generally most of it is. But if you go to digitalcompliancehub.co.uk, you can at least get a feel for what that's about. So that was all I wanted to say at this particular point. If anybody's got any questions, then we can pick those up now. I've not got any coming through just right now, but if you want to ping me any questions, then I'll try and pick those up. Thank you, Lulu. I've got some thanks for the presentation, but no questions, which is good. If there aren't any other questions, then we can close it off a little bit early. I obviously started late because of technical problems, but Still a few minutes if anybody's got anything they want to come through. And as I said, I've been recording the session, and I'll distribute that probably over the coming week with a copy of the slides. So even if you want to use these slides as a prompter for your employees, then that's a good way of communicating sort of the basics of compliance, or at least talking to it with regards to your employees and training. Okay, well, let me just check. I haven't got any questions coming through. So if that is it, I certainly got nothing else coming through other than some thanks. So thank you very much for your time. I hope you found that useful, and I hope you can make use of the recording afterwards along with the slides. But in the meantime, apologies again for the slightly problematic start. I'll try and make sure that that's sorted for the next one, and just to actually fill you in that this is the first of a number of post GDPR webinars I've got planned coming up for the rest of the year. So if I've remembered it correctly, the next one is about the privacy regulations, but I'm covering things like subject access requests and how to deal with those, how to deal with data protection impact assessments, and so on. So have a look at the Digital Compliance Hub website. There's an events menu item you can click on, and that'll give you a list of what's available, and you can sign up for there. They're all free, have a look at those. Sorry, the reason I was hesitating was I was whilst talking, trying to read a question that's come in. Yeah, thank you for that. Somebody's saying that they tend to inform the data subject whether or not it's a high risk. Is that a right thing to do? Well, I mean, that's a really good question. I think that will depend probably on the circumstances of the kind of data and the kind of breach. From a strict law point of view, as I said, the law says that there is high risk to the data subjects. So if you're dealing with very sensitive data or special category data, then I guess there is an argument that some of that could be very high risk if that was to be breached, and therefore it would be reasonable to report it to your subjects. It certainly does no harm to tell your subjects if you're in doubt. The harm that it will do is obviously your reputation, and there is a risk that if you tell the data subjects when you didn't need to, then if you end up getting known for having lots of breaches or lots of issues, then that might have some ongoing harm and PR issues for your organisation. I think that this is really going to come down to the circumstances of the breach. That the law doesn't require it unless there is a high risk, and the high risk is going to be if you're processing special categories of data or lots of data that could have impacts and damage to the individual, particularly if they would need to take some action to rectify the breach in the first place. So yeah, so I hope that answers that question. Okay, well, unless anything comes through in the next couple of seconds, I'll say let's leave it at that. Thank you very much for joining, and yeah, have a look at the Digital Compliance Hub if you're not already using it, to see how that might be able to help you with your breach processes, or indeed any other aspect of compliance.